In President Trump's one term, he was able to appoint 3 justices to the Supreme Court. Aside from the debate about blocking an Obama nominee or rushing through a nominee within days of a 2020 election, the outcome is straightforward. We now have a Supreme Court with a 6-member conservative majority. This newly aligned court provides the possibility of upending decades of legal precedents on issues as fundamental as affirmative action, voting rights, abortion, and gun rights. Linda Greenhouse, a Pulitzer Prize winning journalist who covered the Supreme Court for the New York Times for 30 years and is currently a lecturer and senior research scholar in law at Yale Law School. She brings her classic clarity and insight to analyzing the first year of this new court and what it means for the future. In her new book, Justice on the Brink, The Death of Ruth Bader Ginsburg and the Rise of Amy Coney Barrett, and 12 months that transformed the Supreme Court. Linda, welcome to Just the Right Book.
Thank you. Delighted to be here.
So I'd like to spend our time analyzing, as you have in the book, where we now stand on these major issues like abortion, religion, voting rights, gun rights, and also how the standing of religion has maybe slipped from assuring treatment of neutrality to one of preference. But first, I would like you to help our audience understand more about the woman, Amy Coney Barrett, a religious conservative who replaced the legendary liberal Ruth Bader Ginsburg. On the one hand, Justice Barrett at a recent speech said, "My goal today is to convince you that this court is not comprised of a bunch of partisan hacks." On the other hand, at a graduation speech to the class of 2006 at Notre Dame Law School, where she was an alum, she said, "Keep in mind that your legal career is but a means to an end. That end," she explains, "is building the kingdom of God." So which quote, Linda, is more indicative of the woman who stood on the Truman balcony in late October of 2020 to be sworn in as the newest Supreme Court justice?
Yeah, I mean, that's the money question. Of course, my book begins with that scene on the Truman balcony. That really was just bizarre. I mean, the election was underway. Millions of Americans had voted already. And there she was in the Klieg lights with the president who had pushed this who had nominated her before Ruth Ginsburg was even buried. So which is the true Amy Barrett? I mean, I think her remark about we're not a bunch of political hacks was, of course, was oddly made at a very political event at the Mitch McConnell Center in Kentucky. And of course, it was Mitch McConnell, the Republican leader of the Senate, that had blockaded President Obama from filling the Scalia vacancy and had pushed through the Gorsuch and the Kavanaugh and now the Barrett nominations. Somehow she persuaded herself that politics had nothing to do with any of that. I don't know. The kingdom of God remark. So as you said in your introduction, the rise of religion as the preferred right is really a theme of this term. And of course, she was a vote that helped enable that. She was not alone. The Chief Justice has that as one of his projects as well. So will she be the one who finally tilts the court over the edge on this? There's a collective. I am trying to keep an open mind on what her role is going to be.
And she hasn't been as aggressive in the first year, let's say, that in the way Neil Gorsuch had been. It seems like she either is being diplomatic or just more thoughtful. And so it seems to me, from what you say in the book, there's not a clear indication other than her historical comments. She wasn't a judge that long.
No, she was a judge for just 2 years. Yeah, I mean, there are very few data points.
Right.
It's early. I mean, here we are Now the court's been back in session for a month and a half, and not surprisingly, they have not issued a full opinion yet. Of course, they did something very major on September 1st when they let the Texas vigilante law go into effect with Amy Barrett's acquiescence. She didn't write anything, but to stop the Texas law would have taken 5 votes. And the court had only 4, Chief Justice Roberts and the 3 liberals. She could have given them her vote. Brett Kavanaugh could have given them his vote. Nobody on that side of the street gave a vote. And so the Texas law went into effect and is still in effect.
Yeah. So let's back up and go through that. So the abortion law that's been in the news is the Texas law that does 2 things that are at odds with Roe versus Wade. And one is just like at odds with any historical precedent. So one is, because it's unconstitutional to ban abortion, but that's a relationship between the state. The Texas law bypasses the state and instead puts in place what I think you'd have to call a vigilante, meaning somebody can take someone and charge them for having provided an abortion.
Yeah, not charge them, but sue them civilly, sue them for damages.
And the second part is where the Texas law changes the date of viability to 6 weeks from the 23 to 24 weeks. That's the standard in Roe versus Wade. So let's talk about how will the court separate out the 2 issues. So the first one that came up was the stay of the law. Under what grounds, or what was the judicial reasoning for not staying the law?
So the question for the court was what's called pre-enforcement review. So the law had not taken effect. The abortion providers in Texas urgently asked the court, stop this law from taking effect so that we have time to perfect our lawsuit and have it work its way up to the courts and get up to you while the law is not in effect.
Right.
So the question is, because nobody has sued anybody under this law, how do you get to court? I mean, the typical case is, somebody gets sued and they say, stop it, put this whole thing on hold. And it's a very deliberately contorted and baffling procedural mess.
But clever. I mean,
clever,
because
fiendishly clever.
Yeah.
And that's the whole point of it. The whole point of it was to insulate Texas from being accountable for a flagrantly unconstitutional law. Everybody agrees, there's no dispute that under current abortion law, which has been the law for almost 50 years, you cannot prevent a woman from getting an abortion before fetal viability. 6 weeks is obviously months and months and months before viability. So there's no doubt that the law is unconstitutional. The question is, can anybody get relief from this law?
So if a person provided an abortion and was sued by a citizen, could they then bring the case to the Supreme Court somehow?
So the theory is that the suit would have to go through, it would be a suit in state court, and the suit would have to be accepted by the clerk of the court and administered through the apparatus of the court and ultimately decided by a judge of the court. These are all state employees, of course, and that they can be sued. That's the theory. It's a pretty good theory. The obstacle right now is that none of that has happened yet.
Right.
So, I think it's pretty common ground, no, nothing's common ground when it comes to abortion, but I think it's a highly plausible situation that these state employees are liable to sue, but first they have to do something. So can you get into court before anything has happened?
So will any incident bring back to the Supreme Court the question of staying the law? Or will it have to go through what could be an extended process and remain law until that happens?
Well, the court a couple weeks ago, earlier this month, heard arguments in two cases. One brought by the providers, the other brought by the United States, by the Biden administration on behalf of the government.
Right.
And the claim there is that aside from all this procedural mess, the Texas law is an affront to the sovereign interests of the United States, because Texas is flagrantly defying constitutional laws interpreted by the Supreme Court and shouldn't be allowed to get away with that. And so the government, as the government in defense of the federal system, which assumes that states are bound by federal law under the Supremacy Clause, went into court on that basis. So
have they agreed to hear that yet?
They heard it. They heard that case and the private providers case.
But they haven't ruled.
They haven't ruled yet. So in answer to your question of, is anything going to happen? They've taken both those cases now under advisement.
Yeah.
And presumably they've taken a vote. Of course, we don't know what that vote is. And an opinion in one or both cases has been assigned, and they're working on it. So eventually we'll hear something.
So one of the things that occurred to me as I was reading the discussions in the book about this is, it almost got me back to thinking about the framers of the Constitution, right? Where there was the issue of, was this a confederation of states or states consolidation? Because you could see if all of a sudden states can carve out, well, this doesn't apply to me. Well, New York could say, no guns, and California could say something else. I mean, it would seem to me, even if the justices who want to change the abortion law would be nervous about what this all looks like as a rollout, if Texas could get away with this.
Well, this came up in the argument, actually, and the government made the argument, and several of the conservative justices and liberal justices both picked up on it, which would be, okay, if we let Texas devolve its enforcement mechanism of this law onto any private citizen that somehow
and bypassing the Constitution,
right? Or not even the bypassing the Constitution part, just we, the state, we have nothing to do with this. So let's say hypothetically a blue state that doesn't like where the court's been going on guns says, okay, we don't care what the court has said about guns. We don't want that to apply here. And so any one of our citizens is empowered by us, the state, to sue whoever they know has a gun. So that seemed to sort of get the attention, certainly, of Justice Kavanaugh asked about it. The whole thing is so bizarre and totally unprecedented. It's totally in a brand new landscape. So it's just really interesting.
So talk about unprecedented. There's another abortion case that's in Mississippi where they are banning abortions after 15 weeks. And historically, if I read it correctly, the Supreme Court has been unwilling to take those cases because the precedent is Roe versus Wade. So what was the basis in the thinking for accepting the Mississippi case?
Well, your observation is correct. I mean, the red states, the anti-abortion states, have been, flooding the lower courts with cases that are flagrantly unconstitutional, get struck down by a district court, goes up to the courts of appeals. The courts of appeals, as the Court of Appeals did in this Mississippi case, strikes down the law, saying there's clear precedent on the books, which is that before fetal viability, a woman has an absolute right to terminate a pregnancy. So why would the court take this case? That, I think the answer has to be, there's a critical mass of justices who don't like the current law and see this case as a vehicle for undermining the right to abortion. So I chronicle in the book the fact that it took months of private discussion and, let's assume, negotiation behind the scenes among the justices to decide what to do with Mississippi's appeal. if the court had acted as the court has acted for years, they just would have denied the appeal. And the lower court decision that struck down the law would have been the last word. But they took the case, and there's no reason to take the case except they want to change the law.
But it's legal for them to take the case.
Oh, the court can take any case
Whatever they want.
I mean, well, that's an overstatement. The court can take any case that falls within the jurisdiction of A, the federal courts as a whole, and B, the Supreme Court specifically. If a case is not in their jurisdiction, if it doesn't present a live controversy, for instance, the federal courts have no jurisdiction. But clearly the court had a perfect right to take this case. The question is, why did they take the case?
So one of the things I thought about, so Roe versus Wade, which passed in
Was decided in
1973, was a 7-2 vote in favor of banning abortion.
No, in favor of the right to abortion.
The right to have an abortion. When did abortion, what were the circumstances that made abortion such a partisan issue? Because it wasn't then, with a vote of 7-2. And in fact, Ruth Bader Ginsburg at her confirmation hearings in 93 said that she was pro-abortion, and she got approved 78-22.
Oh, I think it was like 98-2. Actually.
Oh, well, even more to the point.
Yeah. No, well, you're absolutely right. So at the time that the court decided Roe against Wade, the Gallup poll indicated that there was overwhelming support for the notion that the decision for an abortion should be between a woman and her doctor, government out of the picture. Abortion had been criminalized for decades, and there had been a growing sense in the country, first among the medical profession, within the elite ranks of the legal profession, eventually by the women's movement. It was not a big issue for the women's movement until somewhat later, that the notion of criminalizing abortion, driving women to the back alleys, risk to their lives, that it was just time to reform that situation. What happened was, in the aftermath of Roe, there was not, as many people think there was, a kind of immediate backlash. That's a myth.
Mm-hmm.
What happened was smart Republican operatives around Richard Nixon, who was president at the time, said to him, this is an opening for us.
He too had 3 appointees, right?
He
Nixon.
Did. He did. He was, yes, and he had 4 appointments, and 3 of them were in the majority in Roe. So that the Republican Party was really the pro-choice party. Historically, why? Because Catholic voters tended to be Democrats. And so,
I hadn't thought about that switch that happened.
So what happened was these Republican operatives said, we've been so successful with our strategy in the South and playing the race card in the South, and we've driven white Southern voters away from the Democratic Party by the Southern strategy. We can have a Northern strategy, and we can pull the ethnic, urban Catholic voters away from their traditional home in the Democratic Party if we make our issue abortion. And we can use it as a tool of party realignment.
Wow.
Didn't happen overnight. It took about 10 years. It fueled the rise of Ronald Reagan. I mean, the first presidential cycle after Roe was decided in 73 was 1976. And the Republican Party platform at that time offered a big tent on abortion. They weren't going to come out against abortion because so many Republicans
were pro.
It wasn't until the platform of 1980 that the Republican Party adopted an anti-abortion plank.
So it was a political strategy.
It was
to get, because the other thing that's curious, which I hadn't quite focused on, is the religious makeup of the Supreme Court is one Protestant or one non-practicing Catholic, and predominantly Catholics and Jews.
That's correct. I mean,
Was that deliberate to get Catholic justices on the bench?
well, you can get a debate going. What I say in the book, which is my belief based on my observation, is that all the conservative Catholic justices, and I include in this Neil Gorsuch, who currently is an Episcopalian. He was raised Catholic. He went to the same Jesuit boys' school that Brett Kavanaugh went to.
Mm-hmm.
So I count him as having Catholic roots. They all were appointed by Republican presidents who were pledged under party platform to pick judges and justices who would overturn Roe against Wade. And, a president can't ask a potential nominee, by the way, would you overturn Roe? If the president asked that question, the nominee couldn't answer it. So religion, Catholicism is kind of a proxy for the question that can't be asked and couldn't be answered. That's my view of the matter.
So Linda, you said there was a Gallup poll or whatever kind of poll in the 70s. Wouldn't a Gallup poll today show the majority of people in favor of pro-choice?
The latest poll shows about 80% of the public does not want the Supreme Court to overturn Roe against Wade, like 80%.
But now it doesn't matter, or seemingly that won't matter if public opinion. So what do you think will happen this year on the court? So we've got the Texas case and the Mississippi case. Knowing what you talk about in the book about the standing of the each of the justices, what's your speculation about what will happen?
Well, as I said earlier, there's no reason to have taken this case unless they want to make a change. How fundamental a change they want to make? Do they want to overturn Roe explicitly, or do they simply want to overturn it functionally without quite admitting what they're doing? We'll see in this term. But my view of the implications of this. So the fetal viability rule, which started with Roe and has been maintained for close to half a century, the rule being that before fetal viability, a woman has a right to choose to terminate a pregnancy. That's been the firewall that has protected the right to abortion, even as the court has nibbled away and enabled states to put up all kinds of obstacles, barriers,
admittance, conditions,
waiting periods,
counseling,
all that kind of stuff, But at the end of the day, the woman has the right. Once you get rid of the viability, what I call firewall, where are you?
Mm-hmm.
What's the guiding principle? 15 weeks? Okay, why not 12 weeks? Why not 6 weeks like in Texas? Why not 0 weeks, as some states are trying to do, ban abortion at the moment of fertilization? So it's crucially important to maintain that firewall, the principle behind it. And if the court does away with it, breaches it by upholding the Minnesota 15-week ban, it's very hard to think that the right to abortion is still there.
Yeah. So many of us think about abortion as aligned with a religion, which in some cases, as you're talking about, the original strategy was not about religion. It was a political strategy, but it's often associated with that. So I want to go to the issue of religion because it was fascinating to me to read, which I had never understood the foundational principles regarding religion, are two clauses. The Establishment Clause, which prevents the government from endorsing or coercing a religious practice, and the Free Exercise Clause, which requires the government to leave the believer free to practice their faith. So how are these clauses getting changed and redefined?
Right. So there's some obviously inherent tension between the two.
Right.
Because to the extent that the government gives free rein to somebody's free exercise, that is to say, for instance, giving all kinds of exemptions to laws that ought to apply to everybody, but somebody says, I have my religion says I can't follow this law. At a certain point, that's going to, or at least notionally, interfere with the Establishment Clause and amount to a government thumb on the scale for religion, to the extent of saying that religion has a privileged place in our civil society. The tension was always kind of there, but resolved by, as Chief Justice Rehnquist, the current Chief Justice's mentor and predecessor, said, we have to leave some play in the joints between those two clauses. What's happened in recent years, and this predated actually the Donald Trump rise of the 3 Trump justices, the Establishment Clause has essentially been effaced, and the Free Exercise Clause has been given much wider rein than it's had traditionally. So we saw that really in spades this term, as
a lot of COVID rules,
a lot
right?
of COVID rules, where the question was, could the government, trying to stop the spread of the pandemic and issue capacity limitations on indoor gatherings of all kinds and all different kinds of places, to the extent that that ran up against the number of worshipers that a church would like to be able to accommodate, does that violate the free exercise of religion? And the court, before Ruth Ginsburg died, before Amy Barrett came on the court said, no. The court upheld those regulations by votes of 5-4, with Chief Justice Roberts joined by the then 4 liberal justices. Within weeks of Amy Barrett coming on the court, another case like that presented itself, a case from New York, and the court flipped. And 5-4, religion prevailed over public health. That was a very significant turn of events. And it went on from there. That was not the only case. It continued throughout pretty much the duration of the term. And the court ended up having made, really substantial new law about free exercise. And we'll continue to see that playing out this term and in terms to come.
But Linda, one of the things that surprised me, and I'm not sure I have this right, but when you had talked about, we've obviously heard about a religious organization not wanting to provide contraception or insurance to cover abortion because it's at odds with their religious conditions. Let's say you could make an argument and say that you understand that. But what surprised me is that general non-religious law, let's say the inability to discriminate against an employee because of pregnancy or a disability or something, that some of the cases have allowed religious organizations to say that general laws that have nothing to do with religion don't apply to them. Did I read that right?
Yes, you did.
So what's the reasoning of that?
So the reasoning there, and it's something that's kind of jumped the shark, you might say. The lower courts had created something called a ministerial exception to anti-discrimination laws. So that meant, with the kind of limited look at it, made perfect sense. I mean, you're not going to tell the Catholic Church that it violates the federal law against sex discrimination on the job to refuse to have women as priests, right? So
no, right.
So a church, any church should be free to choose its leadership and run its religious business, obviously, without the government butting in. But what about the teachers in a religious school? So this was a case that came up not in this past term, but the term ago. There were 2 teachers in parochial schools. One was a victim of age discrimination. The other was a victim of disability discrimination. And they sued under the relevant federal laws. Neither of them had special training in religion. They taught lower grades, just kind of basic 3rd grade, whatever. they did, bring the kids to the chapel, and they had something to do with, making sure that the daily prayers were said and so on. But they were not teaching religion. The lower courts had found that the ministerial exception did not extend to employees like that, and that they had a right to pursue their anti-discrimination rights
rights
under federal law. And the Supreme Court overturned that and extended the ministerial exception. So that's an example of, what we were talking about earlier.
Like mission creep.
Mission creep, indeed, that's very good. The privileging of religion in all aspects.
So we could spend a lot of time on each of these topics, but I'm going to move us on to voting rights. So voting rights are now very front and center, and have been even before, Trump wanted to object to the outcome of the 2020 election. There's been erosion. So in reading your book, there are we have the Voting Rights Act of 1965 that established a clear set of laws to protect voting rights of all of our citizens. And there are three key sections that you talk about in the book, section 5, 2, and 4. And it seems like these are now being called into question and diluted. So share with us what those sections are and how they're getting diluted, and what does that mean?
Yeah, so they're more than getting diluted. Chief Justice Roberts wrote for a 5-4 majority back in 2013, a case called Shelby County, people might have heard about, that basically disabled Section 5, which was a very key section that required states and parts of states that had histories of discrimination in access to the ballot, required them to get federal pre-clearance, federal permission from the Justice Department or from a federal court before they made any changes in their voting rules. And Section 4 was the section that listed those jurisdictions. So that's out the window. There's no more pre-clearance. The case that was decided at the very end of this last term.
And how they justify that under the law that existed?
So the majority opinion by Chief Justice Roberts said, well, things have changed. Things are better now. There's no obstacle to Black people voting. And so this list of jurisdictions under Section 4 is really outdated. It hasn't been changed for a long time.
Because that was just so that we clarify it, because that section was talking about historical discrimination. So Chief Roberts was saying that history is no longer applicable. There are no longer historically discriminating practices. Do I have that correct?
There's not enough to justify the kind of, heavy boot of the federal government having to give permission to these jurisdictions to make any changes. And so, technically the Shelby County decision left it open for Congress to amend Section 4, do a new study, list fewer different other jurisdictions that would be covered. But one had to know that Congress is not going to do that as a matter of political reality. So Section 5 is dead in the water. There's no more pre-clearance. That leaves Section 2. Section 2 applies to the whole country, and it prohibits any voting practice that has the purpose or effect. It doesn't require intent, purpose or effect of making it more difficult for certain groups to vote than other groups. So that was the section that was at issue in the big voting rights case this last term. Section 2 was used to challenge voting regulations in the state of Arizona that had the clear effect, as a matter of fact, of disabling Native American and African American and Latino people from using the franchise as frequently, as easily as whites. One of the rules banned the use of, banned the collection of mail-in ballots by other people.
Right.
Unless you
Like
mailed
a
it.
collection.
Yeah. The pejorative term is ballot harvesting. That's a negative term, but what it, in reality, what it meant was on these vast Indian reservations in Arizona where there's no public transportation, there's very few post offices, people can't get to them.
Very few polling stations.
Very few polling stations. So people would, collect mail-in ballots in groups and take them in a bunch to the post office. And Arizona decided to ban that. So that obviously had a disparate effect on the people living in those reservations. And the other practice that was at issue in the case, Arizona law said that if somebody votes in the wrong precinct by mistake, their entire ballot is thrown out. Even the votes for statewide offices where it shouldn't matter what precinct you voted in. That was found to have a disparate effect on minority voters, because it just happens that Arizona changes the precinct lines in those neighborhoods more often than in white neighborhoods. And so it's quite common that people show up to vote where they voted last time, and turns out they're in the wrong place.
Because they might not have known.
Exactly. So the question was, what standard to use under Section 2 to evaluate challenges to laws like that? And Justice Alito wrote the majority opinion.
Right.
5-4, and found that, well, really, we look back at history, the people, the Congress that wrote the Voting Rights Act in 1965, that amended the Voting Rights Act in 1982, these practices wouldn't really have bothered them, and this isn't what they're talking about, and we just kind of enough with this interference by the federal government into what states and localities choose to do with their voting practices. And Justice Kagan wrote a blistering dissenting opinion about this, but there we have it. And of course, it's very troublesome, given that we know that the Republican Party nationwide has a strategy of trying to erect all kinds of obstacles to polling places and polling and voting practices in minority communities in this country.
Linda, the thing that the voting rights really made me think about, so there was a legislative bill passed, right? The Voting Rights Act of 1965. And it started making me think about the lines getting blurred between setting policy judicially versus setting policy legislatively. And then I read in the book, which I had never heard this term, that there's a term called majoritarian difficulty, which expresses the dilemma at the heart of the power of judicial review, the power of the courts composed of unelected judges to overturn legislation enacted by democratically elected legislators. Have we seen a change in where the courts are setting policy that looks like a legislative prerogative?
Well, I'm not sure I would say, have we seen a change? I mean, of course, Brown against Board of Education overturned the racial policies regarding the public schools, across the South. So I think what's happened now is that the power of the courts has been harnessed. Instead of expanding rights, it seems to be harnessed in service of restricting rights.
Mm-hmm.
And take the situation with abortion. So, it's hard to think of. I mean, I can't sit here and say the court has never retracted a right that it has recognized previously. But it's really startling that a right that has been, you might say, on the books, that's a little, generic, but for nearly 50 years, the court has it in its power to say, forget that, never mind. And that's a very concerning thing about judicial power, for sure.
Yeah, I mean, I haven't, obviously I've thought about it in a macro level. I haven't thought about it in a micro level like I did reading your book. And then that's what got me thinking that the judiciary is in some cases overriding legislative agendas. And you're right, Brown versus Board of Ed did exactly that. It's just that there were a lot of us that agreed with that.
Well, so let's think for a minute about Obamacare, the Affordable Care Act.
Right.
So I spent a lot of time in the book talking about the case that was pending last term,
Right.
that would have had the effect of dismantling the Affordable Care Act. And if people remember, in the confirmation hearing for Amy Coney Barrett, Democratic senator after Democratic senator basically said, if she goes on the court, she will be the vote that will finally, this is the third attack on the Affordable Care Act that was pending before the court, will finally achieve the Republican agenda of getting rid of the Affordable Care Act. I mean, that would have been an example of what you're talking about.
Mhm.
I mean, the Affordable Care Act not only had been, passed 10 years before, but had been preserved in dozens and dozens of votes in Congress where the Republicans tried to, quote, repeal it, and those votes always failed, and so they turned to the court. Now, the court did not play that game. The court didn't play.
Yeah.
The court found that
So that was a surprise.
that was a surprise. The court basically found that the state of Texas, which had brought the challenge to the law, didn't have standing, didn't have enough skin in the game to justify it bringing a lawsuit. So that was kind of a way out, and the Affordable Care Act survived. But that was an example of an effort to use the court very aggressively to achieve what
legislatively,
to achieve what they could not achieve legislatively.
Right. So let's cover one more topic before I ask some more general questions. So gun rights. Gun rights obviously hinge on the Second Amendment, and the debate forever has been whether the right to carry arms was related to the militia or related to the individual. So let's start with what the Heller case decided, and how is that informing a case now coming before the court from New York?
Yeah, so Heller, in 2008, the court held for the first time in a reading of history that had never been read that way before, said that the intent of the Second Amendment was to empower individuals to keep a gun at home for the purpose of self-defense. That was the holding of Heller. Obviously opened up a whole can of worms. Okay, if you can keep it at home, how about outside your home? Concealed carry, open carry, what kind of weapon, where to go, all that. All those questions were raised by Heller, not answered by Heller, and not answered in all the years since Heller. Because why? Because there never were 5 votes on the court that could coalesce and find an answer.
So they never heard a case.
They never heard a case. To the great frustration of conservatives on the court, like Justice Thomas, more recently, Justice Alito, Justice Gorsuch, who would say, we're turning the Second Amendment to a second-class right. That was their mantra.
Right.
So finally, in this last term that I write about, the court decided to hear a challenge to a New York law that makes it quite difficult to get a license to carry a concealed weapon outside your home. All the states have some kind of gun licensing law. New York has one of the stricter ones where you have to show not only that you're a law-abiding citizen that knows how to handle a gun, but that you have a special need for self-protection outside your home, a need that distinguishes you from all the rest of the population. So the law was upheld by the lower court. The NRA affiliate organization in New York brought the lawsuit on behalf of 2 individuals. So that's the question. What does Heller mean? how far does it extend? What does the Second Amendment mean today? And the case was argued earlier this month. It does seem that the New York law is not going to survive. And the question then is the Supreme Court going to become sort of the gun licensing agency for the whole country? That, you know, you can carry a gun here, but what about the subway? But what about the campus? But what about this, that, and the other thing? All those kind of questions came up during the argument. They didn't have very clear answers. It's going to be a complicated question for the court, and we'll see.
The other thing that it brings to mind, like in the two court cases that are currently being decided, the Rittenhouse and the Aubrey case, there's an odd thing that I hadn't quite focused on that you realize in reading about them. They both are using, both defendants are using self-defense as a reason for what they did. But you've got this kind of crazy thing going on. If you're unarmed and I'm armed and I'm pointing a gun or a rifle at you, and you, the unarmed person, feel that the way to protect yourself is to grab the gun from that person, and now the one who owned the gun can say, well, my life was being threatened because he tried to take my gun and shoot me. So that's an odd juxtaposition of sort of having created the need for self-defense. I mean, do you think the courts, that this New York case and this extension of the Heller case is going to begin to even address those kind of complexities?
Well, the court really has to think long and hard about what it's doing. I mean, the week that the court agreed to hear the New York case, there were 3 gun massacres somewhere in the country.
I know.
The country is drowning in guns, right?
And then there was an article today in the front page of the New York Times about ghost guns where you can buy the components.
Yeah. So we've got a real problem in this country. And the court's going to be an enabler of that problem not going away if it rules the way it seems like it's going to rule. And, your question is a good one. And it's going to be incumbent on the court to give us some kind of answer.
Well, but before we end, I hope you're going to help me come up with something that doesn't leave us too hopeless. But I want to ask this question that, one of the things that we've watched Mitch McConnell do. So Trump appointed and got confirmed 200 judges.
Right.
Let's start with a little thing. How does that compare to what Obama got approved? Do you know?
It's more, certainly more, because the Republicans who held the Senate for most of Obama's time in office, refused to give hearings, blocked a number of those vacancies. So when Trump came in, he had, I think, he had dozens of vacancies that Obama had not been permitted to fill. And he moved very quickly and made it a very high priority. And as you say, more than
Linda,
200.
what is the legal or the legislative right to do that? Is that like, okay, my party's in the majority, I get to do what I get to do? Is it no more complicated than that?
Yeah, I mean, the Constitution says the president shall nominate, by and with consent of the advice and consent of the Senate, through the confirmation process. So the Senate really gets the last word.
Because the other thing that I hadn't realized, and I'm not sure I even understand this, that there was a carve out from the filibuster rules for Supreme Court nominees. Is that correct?
Well, what happened was the Democrats had gotten rid of the filibuster for the lower courts because the Republicans had used the filibuster to prevent President Obama from filling the lower court seats. And for instance, the seat on the federal appeals court in Washington, D.C. that John Roberts had filled before he was promoted to the Supreme Court was left vacant for 5 years. And
so did the Democrats get hoisted by their own petard?
So
it sounds like it.
So then the Republicans for the Scalia vacancy said, well, yeah, exactly. I mean, now we're going to repeal the filibuster for the Supreme Court. So all they needed to confirm Neil Gorsuch was 50 votes plus Vice President Mike Pence, right? So that's the situation.
Yeah. So we have like 3 minutes left. This hour has certainly gone quickly. So let's talk about the future. As we said in the introduction, we now have a conservative majority, but part of that conservative majority is John Roberts as the Chief Justice. And not every nominee behaves judicially in the way that might have been expected. There's a lot of talk about John Roberts wants to be very sure that the court's integrity is a non-political organ, which was one of the things I wanted to talk about, but we won't get to that. So how do you see John Roberts' leadership? Because there were a couple of fissures even in the conservative bloc in the year that you discuss in the book. What do you imagine, having studied the Supreme Court for decades? What will the Roberts Court look like, or will it turn into the Trump Court? What do you guess is going to happen?
Yeah, so that is it the Roberts Court in more than name, or is it the Trump Court? Is really the question that kind of runs through my book. And at the end of the day, I guess I give a kind of equivocal answer. We don't quite know the answer yet, but I think what we saw in this term is a reversion to the way the court was, frankly, when I started covering the court for the New York Times in the late 1970s, which was that it wasn't what people that have come of age in the last couple of decades came to think of the court. 4 justices on one side, 4 justices on the other, Anthony Kennedy in the middle. And if you're going to take a case to the court, you got to make sure it's a case that's going to get Kennedy's support, or you're not going to prevail. Classically, that's not the case. When I started covering the court, there were 3 or 4 justices kind of in the middle.
Mm-hmm.
If you were going to say who's the leader of the court, you'd be very hard pressed to name one. And I think that's where we're going right now. So, John Roberts' name is on the door. He has many skills, and he deployed many skills in this last term that I described.
He just for our audience, that he's a strategic, patient judge.
Yes, and he cares about the court. As I say, his name is on the door. Any Chief Justice cares about the court. But what kind of running room he's going to have with the 5, really seriously conservative people to his right, he's only 1 vote. They each get only 1 vote. Yeah. And it's a real challenge.
And do you think, they all get 1 vote, but he's a Chief Justice, and the leadership of a Chief Justice historically can help coalesce the justices in their thinking and strategy. Do you think in the makeup of this court, Chief Roberts has the standing with the other justices to provide that kind of leadership?
Not necessarily.
Yeah.
I was surprised throughout the term by how snarky Justice Alito and Justice Gorsuch were in their.
Is that unprecedented, their snarkiness?
Well, precedent's a long time, so I can't say it's never happened, but it was very striking to me that they basically were kind of calling him a wimp when he wasn't going as aggressively or as quickly as they wanted to go.
Yeah.
So they didn't seem to be giving him any cover or cutting him any slack.
So what would you, this is my last question, Linda. What would you, as someone who's observed the Supreme Court all these years, be comforted by, not in terms of your own politics, whether it's liberal or conservative, but what would you like to see happen that would give you confidence that the Supreme Court is operating in the way it needs to preserve its integrity?
I'd like to see the court not set its docket in service of a conservative agenda. In other words, take the cases as they come, take the cases that involve splits in the circuits where, federal law means one thing in the Ninth Circuit in California and a different thing in the Sixth Circuit in Cincinnati. Take those cases that the court needs to take, and don't reach out to take cases that serve the agenda, like the Mississippi abortion case or the New York gun case. And that would give me a fair amount of comfort.
Okay, well, let's hope that is what happened. We've been talking with Linda Greenhouse, the author of Justice on the Brink, The Death of Ruth Bader Ginsburg, The Rise of Amy Coney Barrett, and 12 Months That Transformed the Supreme Court. Linda, thank you for having the conversation. I think that, there's lots of details you had in there, which I was thrilled, because I'm going to follow cases in a very different way now, understanding what you've talked about in the book. So thank you for joining us in this conversation. Thank you for writing this book. And I look forward to your columns in the New York Times to help us understand what's going on in this court.
Thanks very much, Roxanne. It's a pleasure to be here.